May it please, my lord.
Yes, go ahead.
My name is Ochenehi Dominic. My humble appearance is for the first defendant, INEC. Most grateful, my lord.
With humility, my lord, Saidu Adamu, my humble appearance is for the second and third defendant.
The body, okay. Yes. Okay, thank you. Thank you. Okay, Said Adamu. Can you hear me?
Yes, my lord. I'm hearing you, my lord.
Okay. Judgment.
As the court pleases, my lord.
As court pleases, my lord.
The plaintiff initiated this action by an originating summons dated 10th November 2022 and filed 11th November 2022. The plaintiff, Musa Al-Haji Yusuf, praised the court for the determination of 3 questions and sought 5 reliefs. The summons is issued against 3 defendants, namely the Independent National Electoral Commission, INEC, first defendant, All Progressives Congress, APC, second defendant, and Yakubu Suleiman, third defendant, respectively. The plaintiff subscribed the following questions for determination. 1, whether upon the proper construction of the provisions of section 84(5)(c)(1) of the Electoral Act 2022, the second defendant having failed to conduct primaries into the seat of Fika, Galda State, constituency of Yobe State, House of Assembly in accordance with the state section and judgment of this Honorable Court in suit number FSCD-MCS 3/2022, the third defendant can validly contest the 2023 general elections. 2, whether upon proper construction of the provisions of section 84(5)(c) sub 1 and 2 of the Electoral Act and judgment of this Honorable Court in suit number FHCD-MCS 3/2022, the second defendant can, without recourse to the state provisions, declare the third defendant as the winner of the primaries into the seat of Ngalda Fika constituency of Yobe State, House of Assembly. 3, whether upon the proper constructions of sections 84(1)(5)(c)(1 and 2 and judgment of this Honorable Court in suit number FHCD-MCS 3/2022, the second defendant can unilaterally declare the third defendant as winner of the primaries into the seat of Galda Fika State House of Assembly of Yobe State. Relief sought. If the answers to the above questions are in the affirmative, the plaintiff seeks the following reliefs. Thus, A, an order of declaration that the second defendant having failed to conduct primaries with the accredited delegates as directed by the judgment of this Honorable Court into the seat of Galda Fika constituency of Yobe State House of Assembly cannot validly field the third defendant to contest seat of Galda Fika constituency of Yobe State in the 2023 general elections. B, an order of declaration that the second defendant has no power to unilaterally change the name of delegates in negation of the judgment of this Honorable Court and vote in the elections into the seat of Ngalda Fika constituency of Yobe State House of Assembly in the 2023 general election. C, an order of declaration that the second defendant cannot, without recourse to the provisions of sections 84(5)(c)(1 and 2 of the Electoral Act and the judgment of this Honorable Court suit number FSCD-MCS 3/2022, declare the third defendant as the winner of the primaries into the seat of Galda Fika constituency of Yobe State House of Assembly. D, an order of this Honorable Court declaring the return of the third defendant by the second defendant as winner of the primaries of Ngalda Fika constituency of Yobe State House of Assembly as illegal, ultra-virus, null, and void, E, an order directing the first defendant not to accept the candidature of the third defendant or any person from second defendant into the seat of Galda Fika constituency of Yobe State House of Assembly in the 2023 general elections, and F, for such further or other orders as this honorable court may deem fit to make in the circumstances and justice of this suit. In support of the originating summons is an affidavit of 21 paragraphs with 3 exhibits. The affidavit is deposed to by the plaintiff himself. Summary of the facts. The case of the plaintiff, as stated in the affidavit in support of the originating summons, are that the plaintiff is a member of the second defendant with registration number YB/FKA/04/03003. And upon the platform of the second defendant, the plaintiff sought and obtained nomination form as one of the contestants who was supposed to contest in the primary elections of the second defendant into the seat of Galda Fika constituency of Yobe State House of Assembly on the 30th day of October 2022, and that the third defendant is the person whom the second defendant purportedly declared as the winner of seat of Galda, Galda Fika constituency of Yobe State House of Assembly. That the plaintiff had earlier on filed a suit before this honorable court with suit number FSC-GMCS 3/2022, seeking for the intervention of this honorable court to compel the second defendant to conduct a fresh election into the seat of Galda Fika constituency of Yobe State House of Assembly, to which this court delivered judgment on the 19th day of October 2022 and ordered that the second defendant to conduct primaries into the seat of Galda Fika constituency of Yobe State House of Assembly, and that on the 30th day of October 2022, the second defendant purportedly conducted the primaries, which was marred by irregularities and not in accordance with the direction and order of this honorable court, Electoral Act, and guidelines of the second defendant, that the delegates have been illegally tampered with and their names changed. Those who voted were not validly accredited by the first defendant, and the first defendant could not produce the register of the accredited list of the delegates. That congresses were not conducted by the second defendant under the supervision of the first defendant, and in some places, congresses were not conducted at all. At 1, Galda Dumbulwa Ward, 2, Zangaya Mazawun Ward, 3, Turmi Mallory Ward, 4, Fika Anze Ward. That political appointees and civil servants were among the delegates that voted, in which Nuhu Bulama, who is a senior special assistant, the Yobe State Governor, His Excellency, Mai Malabuni, voted as a delegate of Turmi Mallory Ward. That in Fika Anze Ward, Yawa Abubakar, a staff of local education authority, a class teacher in Gashua Primary Fika local government, that 2 delegates from Turmi Mallory Ward impersonated Lamba Manuwachi and Malam Manu in Nahaza, and that the 5 delegates of Galda Dombulwa Ward are not eligible to vote because they were never elected in any Congress. The names were just imported, that the 5 delegates of Zangaya Mazuwan Ward were not eligible to vote because they were never elected in any Congress, that the names were just imported, and that prior to the conduct of the primaries, the plaintiff realized that there was ulterior motive by the second defendant to change the names of the delegates, wrote a letter dated the 22nd day of October 2022 through his counsel, Sahel Chambers, appealing to the national body of the second defendant to prevail on the state chairman of the second defendant, Yobe State, to comply fully with the judgment of the Federal High Court as aforementioned. Also, accompanying the affidavit are 3 exhibits marked as exhibits YB1, YB2, and YB3. Exhibit YB1 is a copy of the membership registration form of the plaintiff. Exhibit YB2 is a copy of the judgment of this honorable court dated 19th day of October 2022. Exhibit YB3 is the plaintiff's letter written through his counsel, Sahel Chambers, dated the 22nd day of October 2022, appealing to the national body of the second defendant to prevail on the state chairman of the second defendant, Yobe State, to comply fully with the judgment of the Federal High Court. Counsel to the plaintiff, Dr. Shamsuddin Magaji, Esquire, in his written address, formulated 3 issues for determination, which he argued together. The plaintiff asked for the resolution of the following questions. 1, whether upon the proper construction of the provisions of sections 845C1 of the Electoral Act 2022, the second defendant having failed to conduct primaries into the seat of Fikan-Galda State constituency of Yobe State House of Assembly in accordance with the said section and judgment of this honorable court in suit number FSC-DM-CS 3/2022, the third defendant can validly contest the 2023 general elections. 2, whether upon proper construction of the provisions of section 845C1 and 2 of the Electoral Act and judgment of this honorable court, the second defendant can, without recourse to the said provisions, declare the third defendant as the winner of the primaries into the seat of Galda Fika constituency of Yobe State House of Assembly. And 3, whether upon the proper constructions of sections 8415C 1 and 2 and judgment of this honorable court in suit number FSC-DM-CS 3/2022, the second defendant can unilaterally declare the third defendant as winner of the primaries into the seat of Galda Fika State House of Assembly of Yobe State. Learned counsel went on to make submissions as was noted and written address. Now I'll skip the submissions of counsel. On being served with the originating summons on the defendants, the first defendant filed its 9-paragraph counter affidavit. It was 2 by 1 Ocheme on 20th December 2022 with 1 annexure accompanied by a written address of same date. The deponent stated that on the 19th day of October 2022, this honorable court ordered the second defendant to conduct fresh primaries in Fika Galda constituency under the supervision of the first defendant, and that the second defendant scheduled 30th day of October 2022, time 10:30 a.m. venue at Fika Town Hall in Fika local government area to conduct fresh primary election to nominate a candidate for Galda Fika State constituency as ordered by this honorable court. That one, Mrs. Afiniki Ethan, is the electoral officer of Independent National Electoral Commission in Fika local government area and the leader of the team that was appointed by the first defendant to monitor the primary election of the second defendant for Galda Fika constituency. And she informed the deponent the following facts, which he believes to be the truth, that on the 30th October 2022, she and her team members went to the venue where the second defendant scheduled the conduct of his primary election for Galda Fika State constituency, and that 3 persons, namely Honorable Yakubu Suleiman Malori, Garba Aliu Malori, and Musa A. Yusuf, contested for the said primaries. after the second defendant adopted open secret ballot system, and after voting and counting in full view of aspirants and their agents, the media, security agents, and INEC staff, the following results were announced by the returning officer. 1, Honorable Yakubu Suleiman Malori have 13 votes. 2, Garba Aliu Malori have 7 votes, and Musa A. Yusuf have 5 votes respectively. The deponent stated that the third defendant, Honorable Yakubu Suleiman Malori, polled the highest number of votes cast and was returned as the winner of the primary election, which was conducted in the presence of all the aspirants and the agents, security agents, the media, INEC staff, and was peaceful. That the electoral officer submitted her report of the conduct of the primary election for Galda Fika constituency to the first defendant. Also accompanying the affidavit is a sole exhibit marked as Exhibit INEC 1. Exhibit INEC 1 is the report written by the electoral officer of the conduct of the primary election for Galda Fika state constituency to the first defendant. Counsel to the first defendant, Ochenehi Dominic, formulated a sole issue, which reads whether the second defendant conducted primary election for Galda Fika state constituency monitored by the first defendant. I'll skip the submissions of Learned Counsel. The plaintiff filed a further 6-paragraph affidavit to the counter affidavit of the first defendant opposing the originating summons. The plaintiff, as the opponent deposed in the to the fact that he is one of the contestants in the purported primary elections. Of second defendant into the seat of Galda Fika constituency of Yobe State, House of Assembly on the 30th day of October 2022, and having read the counter affidavit of the first defendant that paragraphs 1, 2, 3, 4, 5, 6, 7, 8, A, B, and C of the counter affidavit are true, and that paragraphs 8, E, F, and G of the counter affidavit are not true, as the entire purported primary election into the seat of Galda Fika constituency of Yobe State, House of Assembly was marred by irregularities, such as using stooge to impersonate the validly elected delegates, allowing political appointees to participate as delegates, among other irregularities, and that the first defendant did not show the result of the purported primary election. Counsel to the plaintiff also formulated 2 issues for the determination of this court, which was jointly argued together. 1, whether the counter affidavit of the first defendant and the exhibits in support vis-a-vis the written address is not defective and contradictory. 2, whether admission by the first defendant in his counter affidavit needs any further proof by the plaintiff. I'll skip the submissions of Learned Counsel. On being served with the originating summons by the plaintiff, the second and third defendants filed a joint memorandum of appearance with leave of court, sought and obtained. The second and third defendants filed their joint defense by way of counter affidavit and written address dated 4th January and filed 5th January 2022 to the plaintiff's originating summons. The counter affidavit contains 16 paragraphs. Affidavit deposed to by the third defendant. 6 exhibits are annexed to the counter affidavit deposed to by the third defendant. 6 exhibits are annexed to the counter affidavit, being exhibits 1A to 5 and exhibits B respectively. The third defendant, Wani Yakubu Suleiman, deposed the fact that he was an aspirant that contested primary election against the plaintiff organized and conducted by the second defendant on 30th October 2022. For the seat of Fika Nganda constituency of the Yobe State House of Assembly, that the primary election was held to produce a candidate for the second defendant from among the contested aspirants that will contest in the 2023 general election. And that consequent upon the conclusion of the primary election, the deponent emerged the winner, and as a result, the plaintiff instituted this action against the deponent as a third defendant and the APC, All Progressives Congress, as the second defendant. And the primary election was real and not a purported one, which was free, fair, and credible, without any irregularity, as it was organized and conducted in accordance with the directives and orders of this honorable court. The Electoral Act and the guidelines of the second defendant, wherein they contested with the plaintiff on 30th October 2022, that the deponent stated that the delegates who gathered at the venue of the election have their names on the list intact without any change. They were screened at the gate by the law enforcement agents comprising of the police and the Nigerian Civil Defense, and that subsequently the second defendant's officials, led by Honorable Abba Bari, accredited the delegates name by name and word by word under the supervision of the first defendant, officials led by Afiniki Ethan, electoral officer, and Barrister Ochai Gabriel, legal officer, in the presence of the law enforcement agents, and that contrary to the facts in paragraph 13 of the affidavit of the plaintiff, there were congresses conducted by the second defendant under the supervision of the officials of the first defendant, by which list of delegates were recorded covering all the wards, and that there was never any delegate that was impersonated at the primary election as purportedly claimed in paragraph 13 of the plaintiff's affidavit, and that throughout the voting processes, there was never any issue or a point of non-eligibility of any delegate, and no name was imported of any delegate as contended in paragraph 18 of the affidavit, and that the primary election exercise conducted by the second defendant was free, fair, and credible, and was conducted under the supervision and monitoring of the officials of the first defendant, law enforcement agents drafted to provide security cover, that it is not in the interest of justice to grant the reliefs of the applicant, as both the second and third defendant will be prejudiced if the reliefs of the plaintiff are granted. Also, accompanying the affidavit are two exhibits marked as exhibits A and B. Exhibits A1, A2, A3, A4, and A5 disproves and dislodges the assertion, the position of the plaintiff that there was no ward congresses in the wards he listed in his affidavit, while Exhibit B is the list of the delegates for the respective wards. Counsel to the second and third defendants, Sanda A. Yelwa Esquire, in his written address in support of the counter affidavit, and written address, and in opposing the plaintiff's originating summons in its entirety, raised a single issue for determination, to wit, whether or not the plaintiff has discharged the burden to establish its claims for declaratory reliefs. I'll skip the submissions of counsel. Counsel urged the court to dismiss the plaintiff's case with cost as they asked for 1 million naira against the plaintiff. The plaintiff filed a further affidavit to the counter affidavit of the second and third defendants opposing the originating summons, which was deposed to by the plaintiff, who stated that having read the counter affidavit of the second and third defendants, same are not true, concoction of facts, misleading, and not the actual reflection of what truly transpired. That paragraphs 1 to 16 are thereby denied, challenged, or controverted, and that paragraph 6 of the counter affidavit is not true, as the purported primary election into the seat of Galda Fika constituency of Yobe State of Assembly was marked by irregularities such as using stooge to impersonate the validly elected delegates, allowing civil servants to participate as delegates, among other irregularities. That Congress was not conducted by the second defendant under the supervision of the first defendant. And in some places, Congress were not conducted at all. Some of which are as follows: 1, Galda Dumbulwa Ward, Zangaya Mazawun Ward, Turmi Malori Ward, Fika Anze Ward. The deponent stated that political appointees and civil servants were among the delegates that voted, in which Nuhu Bulama, who is a senior special assistant to Yobe State Governor, His Excellency Mai Malabuni, voted as a delegate of Turmi Malori Ward with serial number SSA 169 and has been collecting salaries. That payment slips for the months of August, September, and October 2022 is annexed and marked as exhibits A, B, and C respectively. And in Fika Anze Ward, here Abubakar, who is a staff of local education authority, a class teacher in Gashua Primary, Fika local governments, also voted as a delegate. His letter of temporary appointment, confirmation of appointment, letter to Gashua Primary School, and biometric confirmation are annexed thereto and marked as exhibits D, E, F, and G respectively. The deponent stated further that 2 delegates from Turmi Malori Ward impersonated Lamba Manawati Amala Manu in Nahaza, and that the 5 delegates of Galdadom Bulwa Ward are not eligible to vote because they were never elected in any Congress. The names were just imported, and that the 5 delegates of Zangaya Mazawun Ward were not eligible to vote because they were never elected in any Congress. Their names were just imported, and Garba Ali Maluri, who contested and purportedly became second in the primaries, is a political appointee with ID number NGC 008. Payment slips for the months of October and November 2022 is annexed thereto and marked as exhibit H and I respectively. That paragraph 7 of the counter affidavit is not true, as the first defendant has an obligation to monitor the conduct of the primary elections by comparing the records and or producing the list of delegates earlier submitted to the first defendant by the second defendant, with the list presented on the date of primaries by the second defendant to ensure compliance. That the list of delegates on exhibit A4 of the second and third defendants counter affidavit in Fika Anze, the name of Haruna Masaye was changed with that of Hawa. The deponent stated that in Turmi Malori, all the names in the state delegates were used in place of the names of local government delegates. That in Zangan Mazawun, also the state's delegates were used as local government delegates. That the authentic list of delegates is annexed thereto and marked as Exhibit J. And there was no any comparison on the list, no any screening by the police, civil defense, and or any law enforcement agent. And the lists were defaced in order to rig the election. That in further denial to paragraph 9 of the counter affidavit, there was no supervision of anybody and no accreditation of delegates, word by word under the supervision of anybody. And also, the third defendant did not score 13 votes and there was no any result sheet. That paragraphs 12 and 13 of the counter affidavit are not true. The second and third defendants altered the list of delegates submitted to the first defendant, which caused commotion at the venue, and that the plaintiff and his agent demanded that justice be done by removing the imported names, while the second and third defendants were busy maneuvering their ways on how to declare the third defendant as the winner of the purported primary election. Therefore, the entire counter affidavit filed by the second and third defendant is spurious, contradictory, defective, malignant, sham, and an abuse of process of court. And the counter affidavit as filed by the second and third defendants should not be granted by this honorable court, that it will be best serve the interest of justice to discountenance the aforementioned counter affidavits. And the second and third defendant will not be prejudiced by the said dismissal. The further affidavit is accompanied by 11 annexure marked as exhibits A, B, C, D, E, F, G, H, I, J, and K respectively. Exhibit A, B, and C is the payment slips for the months of August, September, and October 2022 of Nuhu Bulama, who is a senior special assistant to Yobe State Governor, His Excellency Mai Malabuni, voted as a delegate of Turmi Malori Ward with serial number SSA 169 and has been collecting salaries. Exhibit D, E, F, and G is a letter of temporary appointment, confirmation of appointment, posting letter to Gashua Primary School, and biometric confirmation of Yao Abubakar, who is a staff of local government authority, a class teacher in Gashua Primary Fika local government, also voted as delegate. Exhibit H and I is the payment slips for the months of October and November 2022 of one Garba Maluri, who contested and purportedly became second in the primaries. Is a political appointee with ID number NGC 008. Exhibit J is the authentic list of delegates in Zangon, Mazaun. Also, the state's delegates were used as local government delegates. Exhibit K Exhibit K is the certificate of compliance with Section 84 of the Evidence Act. There is a written address of counsel in support of the further affidavit of 7 paragraphs of the plaintiff, arising from a counter affidavit of the second and third defendant opposing the plaintiff's originating summons, to which learned counsel to the plaintiff, Dr. Shamsuddin Magaji Esquire, formulated the following issues for the determination of this honorable court. Thus, 1, whether the second defendant can, without recourse to the judgment order of this honorable court, delivered on the 19th day of October 2022, which mandated the second defendant to conduct fresh primary election using the list of earlier nominated delegates, can turn around and alter the list of delegates in favor of the third defendant. 2, whether the facts and circumstances of this case, the plaintiff has proved his case to warrant this court to enter judgment in his favor. 3, whether the affidavit and the exhibits in support of the second and third defendant's counter affidavit vis-a-vis the written address is not defective and contradictory. Lanark Council jointly argued issue 1 and 2 above together, and the third issue separately. I'll skip the arguments of Lanark Council. The last paragraph of Council's argument that Lanark Council submitted that the plaintiff has established credible evidence based on facts to warrant this honorable court to exercise its discretion in granting the relief sought by the plaintiff. That their affidavit, which has not been challenged and or controverted by the second and third defendants in their counter affidavit, especially that of the third defendant, only resorted to general denial of facts contained in the affidavit in support of the plaintiff's originating summons filed before this honorable court without specifically challenging, denying, and or controverting the affidavit in support of the plaintiff's originating summons. That the third defendant instead resorted to derailing from the facts deposed to in the plaintiff's affidavit in support of the originating summons. The above are the submissions and arguments of counsel in this instance suit. In trying to resolve the issues identified in this matter, this honorable court will adopt the issue as raised by the counsel to the second and third defendant, Sunday A. Yelwa, in his written address in support of the joint counter affidavit and written address, and in opposing the plaintiff's originating summons in its entirety, wherein a single issue for determination was raised, to wit, whether or not the plaintiff has discharged the burden to establish his claims for declaratory reliefs. The plaintiff filed an originating summons against the defendants, challenging the imposition of the third defendant by the second defendant as the winner of the purported primary election for the seat of Fika Galda constituency of Yobe State House of Assembly, Fika local government area of Yobe State, held on the 30th October 2022. The first defendant in their counter affidavit deposed by the electoral officer of INEC confirmed the assertion that primary election held. Paragraphs E to H of first defendant affidavit is hereby reproduced for ease of understanding. Paragraph E, that after voting and counting in full view of aspirants and their agents, the media, security agents, and INEC staff, the following results were announced by the returning officer. Honorable Yakubu Sulaiman Malori have 13 votes, Garba Aliu Malori have 7 votes, and Musa A. Yusuf have 5 votes. F, paragraph F. But the defendant, Honorable Yakubu Sulaiman Malori, polled the highest number of votes cast, was returned as the winner of the primary election. Paragraph G, that the primary election was conducted in the presence of all the aspirants and their agents, security agents, the media, and INEC staff, and was peaceful. Paragraph H, that she submitted her report of the conduct of the primary election of Galdafika State constituency to the first defendant. The said report is hereby attached and marked as Exhibit INEC 1. The attached report, Exhibit INEC 1, is titled Report on the Fika East House of Assembly primary election. Dated 30th October 2022 and signed by one Afiniki Ethan, electoral officer. The signatory of the report on the conduct of the election wrote that, quote, the primary was conducted peacefully in the presence of security men, agents of the candidates, and INEC staff who monitored the primary election, end of quote. She concluded by stating that, quote, there was a demonstration of maturity among the contestants and the presence of the law enforcement agency, such as the police, military, civil defense, ensured a smooth and peaceful APC primary election. I commend the security operatives, the contestants, and INEC staff who attended the primary election, end of quote. The second and third defendant in their counter affidavit asserted that primary election held, paragraph 7, 8, 9, 11, 12, and 13 of their joint counter affidavit is reproduced for ease of understanding. Meanwhile, the plaintiff, in his further affidavit to the second and third defendants' counter affidavit opposing the originating summons by paragraph 3D, 3E, 3F, 3K, 3M, 3P, 3S, paragraph 4 and 5, reproduced below. Now, looking at all the above reproduced processes before this honorable court, there is so much contradictions in all the affidavits of the parties, starting with the first defendant's conduct. This honorable court, having observed that the first defendant, being the Independent National Electoral Commission, a body which is an umpire, have by their exhibit INEC 1 taken a stand that election was held peacefully and a winner has emerged. Therefore, the first defendant and the second and third defendant are at aiding that an election was conducted with accredited delegates, and by which the third defendant emerged as the winner, while the plaintiff is contending that the purported primary election was marred by irregularities such as contradictions in the list of delegates. Some delegates not eligible to vote as they were never elected in any Congress. Their names were just imported using stooge to impersonate validly elected delegates, that political appointees as well as civil servants were among the delegates that voted in contravention of the judgment of this honorable court. The Electoral Act 2022, as well as the ground norm being the Constitution of the Federal Republic of Nigeria, 1999. The plaintiff produced exhibits in proof of such allegations, being transfer letters of civil servants, payment slips of consolidated salary of various months, and offer/confirmation of appointment letters of the alleged political appointees and civil servants. Also by Exhibit J, which are 5 documents titled Summary Result Sheet for Elected Delegates for 5 wards. This honorable court observed that 3 out of the 5 documents have been defaced in some of the columns, in that some names have been superimposed on earlier written names. Same is observed in the local government column as well as the ward columns, which means there is suspicious activity that went on, I so hold. Documentary evidence is used as a hanger to test veracity of evidence, whether oral or by affidavit. Thus, documentary evidence is a hanger to base other pieces of evidence. The plaintiff's assertion that valid primary election was not conducted in accordance with the provisions of the law by the second defendant, in that the second defendant and the third defendant ought to have annexed and showed the result sheet and or report of the primary election duly certified by the first defendant, who are by law empowered to supervise and report the conduct of the election, but only resorted to annexing Exhibit A1 to A5, being summary results for elected delegates 2022, which failed to indicate the total number of votes, number of accredited voters, total votes cast, valid votes and invalid votes. On proof of political party primary election results, the Court of Appeal held in the case of Oliver LPLR, I quote, "I am of the view that the only proof of winning of an election is the election result duly issued. Where there are no results, mere averments by a party cannot stand by the conducting authority."
The court, please.
Quote, "The second and third defendants have failed to produce a copy of result sheets indicating the scores of the third defendant and scores of other aspirants. The burden of proof that valid primary election was conducted lies on the party that asserts that primary election was conducted. See the case of Agagu and others versus Mimiko and others, 2009 LPLR. In the instant case, the second and third defendants have failed to present evidence to prove that valid primary election was conducted, either the certificate of return, result sheet, or the report of the first defendant who supervises and keeps records of elections in Nigeria. See the cases of Tazo versus Yore, Ufomba versus INEC, etc. This honorable court agrees with the submission of Learned Counsel to the plaintiff that the documents filed in support of the second and third defendants' counter affidavit was exhibits A1 to A5, being the second defendant summary results for elected delegates 2022, and the report of result sheet of the purported primary elections of 30th October 2022 that allegedly produced the third defendant as winner of the election, which is not sufficient to prove that there was indeed valid primary elections. Now, with the contradictions observed by this honorable court and the first defendant stand through its electoral officer, a fresh primary elections exercise was conducted into Fika Galda constituency by the second defendant, which was free, fair, credible, and was conducted under the supervision and monitoring of the officials of the first defendant with the law enforcement agents drafted to provide security cover. It's in contradistinctions to plaintiffs, averments, and exhibits. This gives me a cause for concern because the first defendant in its counter affidavit to the plaintiff originating summons admits in its counter affidavit to the plaintiff originating summons admits in paragraph 4 to the effect that paragraph 10 of the plaintiff's affidavit in support of the originating summons is true. The deposition in paragraph 10 reads that on the 30th day of October 2022, the second defendant purportedly conducted the primaries, which was marred by irregularities and not in accordance with the direction and order of this honorable court, Electoral Act and guidelines of the second defendant. The first defendant affirmed above the position in their counter affidavit, and at the same time, the first defendant in a quite contradictory manner annexed exhibits 1 at paragraph 88 of the counter affidavit alleging that the primary election was conducted peacefully in the presence of security main agent of the candidates and INEC staff who monitored the primary election. The first defendant is before this court talking from both sides of the mouth. In one breath, deposing that the primary election is marred by irregularities, and in the next breath, attaching a report stating that the election process was conducted peacefully. This honorable court cannot help but agree with the submission of the plaintiff counsel that the above contradiction will leave this honorable court in a serious state of confusion as to which of the two testimonies or depositions to believe. Moreover, courts are enjoined not to pick and choose because between contradicting pieces of evidence. In essence, the honorable court cannot pick and choose which version of the first defendant's testimony to believe. Counsel referred the court to the case of Nonsu versus State, where it was held that the court cannot pick and choose which portion of the evidence of prosecution witness to believe. It is either the witness is a truthful witness or an outright liar whose total evidence must be evaluated as credible or incredible, as the case may be. See also Kaili versus Hilbuk, 2015, LPLR, Supreme Court. As has been shown above, the first defendant has shown that it is biased which is quite unfortunate. INEC ought to be and should be seen to be neutral at all times. In the case of Hope Uzodinma versus Osita Izunaso, number 2, 2011, 17 NWLR, the Supreme Court, par 5B JSC, stated, I quote, with all the above, the third respondent, Independent National Electoral Commission, said it remains neutral in this episode. They still felt that the appeal should be dismissed. Independent National Electoral Commission, a body which is an umpire, should be seen to be really neutral at all times. In reality, a sympathizer should not weep more than the bereaved. Only heard criers at burials engage in such a mundane ploy. The position taken by the, end of quote, the position taken by the first defendant in this instant case is not in tandem with the admonition by the Supreme Court to the first defendant on similar cases. In the case of Attorney General of the Federation and others versus Alhaji Atiku Abubakar and others, the Supreme Court stated, I quote, the Independent National Electoral Commission, INEC, by its statutory existence, is an independent body with constitutional powers to conduct elections in Nigeria. It must not only be an umpire, it must be seen in the eyes of reasonable men to be an impartial umpire in the conduct of an election. INEC must never, by act or omission or commission, place itself in a position where imputation of partiality in favor of one party against another one will be leveled against it. Neutrality must be the watchword of the body. It must always remain fair and focused, end of quote. The first defendant, as a neutral party and arbiter, did not heed the above admonition of the Supreme Court because the first defendant has stepped into the arena and is talking with both sides of the mouth, I accordingly hold. The parties in this instant action are the same parties in an earlier suit before this honorable court, and we are mandated to reconduct party primary election for the seat of Galda Fika constituency of Yobe State House of Assembly. However, the parties are back. While the plaintiff is contending that the orders of this court were not complied with, the first, second, and third defendants are contending the opposite, hence the suit. This honorable court's quagmire is which of the two accounts given by the plaintiff and the first, second defendants should be believed by the court. Clearly, a situation of conflicting documents in an affidavit evidence had arisen, and this honorable court has the duty to use surrounding facts and documents to resolve the conflicts and choose which among the documents to accept and rely upon in this case. Unfortunately, the documents before the court are not sufficient to meet the standards. There's too much conflict in the affidavit evidence of the parties. Such conflicts can only be resolved by oral evidence or pleadings. In the case of Azubike versus Diamond Bank, PLC 2014, the court held, I quote, where there are two contrary assertions, especially by way of affidavits, the court is not entitled to take a decision in favor of a party without resolving the conflicts, either by oral evidence or the documents, end of quote. In a situation like this, the law is settled that where there is material contradiction in the case presented by the parties, the court cannot pick and choose for the said parties. The only logical and fair course to take in the circumstance is to reject both accounts being contradictory. This court have no option than to reject the account with regard to what transpired on the day of the primary election for the seat of Galda Fika constituency of Yobe State House of Assembly. In support of this, I so hold. In support of the above position of the law, the Supreme Court in APC versus Marafa 2020 held that, I quote, political parties must not act arbitrarily. They must act within the confines of their constitutions and the electoral guidelines and in accordance with the provisions of the Electoral Act. Similarly, in Emeka versus Okadibo 2012, The apex court held the court will never allow a political party to act arbitrarily or as it likes. A political party must obey its own constitution, end of quote. The first defendant cannot clearly and unequivocally admit in paragraph 4 of his counter affidavit that the primary election was marred by irregularities and later turn around in paragraph 8.8 of its counter affidavit to claim that the election was validly conducted. The appeal court held in the case of Ude versus Nora, 1993 to NWLR, I quote, a court faced with two conflicting pieces of evidence without explanations of the conflict is bound to reject both pieces of evidence. A party cannot blow hot and cold. He cannot affirm one at one time, at another time deny what he affirmed previously. He cannot approbate and reprobate, end of quote. See Celtel Nigeria, BV versus Econet Wireless Nigeria Limited and others, 2014. From the observation and perusal of this matter on the issue of primary election of the second defendant, there are disputes as to contradictory facts that are substantial, material, affecting the life issues of the matter, and cannot be fought on the originating summons for due procedure, where affidavit of parties are so contradictory. This honorable court is fortified in this line of thinking by the endorsement of plenitude of Supreme Court decisions. See Alpha versus Atai, Atago versus Nuchin, where the apex court specifically and authoritatively held that where an issue is in controversy, in a suit pertains to the determination of who was lawfully nominated at the primary election, the plaintiff's claim cannot be entertained without pleadings that such an issue is not suitable for hearing and determination by an originating summons, as it calls for oral evidence. His Lordship, Galadima JSC, as it then was delivering the late judgment, stated that, I quote, the court below rightly declined to hear the matter because of the conflicting affidavits. Therefore, since the issue in controversy pertains to determination of who was lawfully nominated of the second respondent at the primary election, the trial court lacked jurisdiction to entertain the appellant's claim without pleadings, end of quote. See also Alpha versus Atai, 2018-5 NWLR. Also, the holding of my Lord Justice Onogen JSC. Now, all authorities and persons have a duty to obey the law of the land and act in accordance with the express provision of same. To do otherwise will enthrone arbitrariness, that the activities of a political party cannot be operated arbitrarily or at the whims or caprices of select individuals, no matter how highly placed. Political parties are creations of the constitutions and statutes. Therefore, the affairs of registered political parties in Nigeria must run in conformity and in obedience to the law creating them. The litmus test for the validity well-known of actions of a political party is that their actions must be consistent with the Nigerian Constitution, the Electoral Act, the Constitution of the party, and its guidelines. From the above outlined facts deposed to by the parties in this suit, just opposing same with the exhibits attached, especially the first defendant counter affidavit, as well as its exhibits, INEC 1, and from the discordant submissions of counsel, it is clear that the second defendant did not conduct valid primaries in accordance with the extant laws to warrant declaring the third defendant as winner of the purported primary elections. I so hold. The Supreme Court, in the case of Namdi, Honorable Namdi Ezeani versus Honorable Jones, Onyerere 2023. Agim JSC held, I quote, since the time allowed by the Electoral Act 2022 for conduct of primaries and submissions of candidates' names to INEC has elapsed, the PDP will not field any candidate for elections for the Imo West Senatorial Zone. See also, end of quote, see also APC versus Godfrey 2017. From the above decision of the Apex Court, no party can conduct a valid rerun outside the time fixed by law, I so hold, and any rerun order made without jurisdiction will have disastrous consequences on the candidates of that political party. The lesson that politicians ought to learn from this case is flagrant abuse of the Electoral Act 2022 and the constitution of the political party does not pay. Political party must allow internal democracy in their parties and avoid arbitrariness, which perpetuates injustice. Whoever decides to disobey the law will have themselves to blame. And from the discordant submissions of counsel, it is clear, as I stated earlier, that second defendant did not conduct valid primaries in accordance with the extant laws to warrant declaring the third defendant as winner. The implication of such misconduct is for this honorable court to invoke the provision of section 84 sub 13 of the Electoral Act 2022, which reads, where a political party fails to comply with the provisions of this act in the conduct of its primaries, its candidature for election shall not be included in the election for the particular position in issue. This court, having been fortified by the above provision of the law, as well as the recent decision of the Supreme Court in Honorable Namdi Ezeani versus Honorable Jones Onyerere, supra in conjunction with earlier cited judicial and statutory authorities, hereby toward the same line and portion to the provision of the Electoral Act 2022 and the Constitution of the Federal Republic of Nigeria 1999. This honorable court holds that since the time allowed by the Electoral Act 2022 for conduct of primaries and submissions of candidates to INEC has elapsed, the APC shall not field any candidate for elections for the seat of Goya, Geji, for the Geji Fika constituency of Yobe State House of Assembly in its 2023 general elections. This matter is hereby dismissed, each party to bear its own cost. This is my decision. This shall be the judgment of this court.
As the court pleases. We are very much grateful, my lord. Even though toward the end, my lord mentioned Goya Geji is Galda Fika, my lord. Thank you very much.
Yes, I realized that and I corrected myself.
Yeah, thank you very much, my lord.
Thank you, Prof.
My lord, may I kindly crave your indulgence before the next case? My learned friend who used to appear in the matter, Hassan S. Saraki, was here somehow when we have announced appearance, and we crave your indulgence and learned colleagues if he can be accommodated. Thank you, my lord.
For which case? The case that has just been concluded?
Yes, my lord.
Yes, I think he is. He has been.
Okay, thank you, my lord.
Dr. Shamsuddin Magaji, and Hassan S. Saraki Esquire.
Yes, my lord. Thank you very much.
Call the next case. Representation, please.
May it please my lord, my name is Dr. Shamsuddin Magaji. Appearing with me is my learned colleague, Hassan S. Saraki. Our humble assurance is for the plaintiff.
Yes.
With profound respect and humility, my noble lord, I am K.M. Haruna, appearing for the first defendant.
With respect and humility, my lord, Saidu Adamu, appearing for the second and third defendant, my lord.
Judgment.
As court pleases.
As the court pleases.
The plaintiff initiated this action by an originating summons dated 10th November 2022 and filed 16 November 2022. The plaintiff, Abdulmumin Hussaini, praised this court for the determination of 3 questions and sought 5 reliefs. The summons is issued against 3 defendants, namely the Independent National Electoral Commission, INEC, first defendant, All Progressives Congress, APC, second defendant, and Ishaku Sani Audu, third defendant, respectively. The plaintiff subscribed the following questions for determination. 1, whether upon the construction and whether upon the proper construction of the provisions of sections 84.5(c)(1) of the Electoral Act 2022, the second defendant, having failed to conduct primaries into the seat of Goya Ngeji State constituency of Yobe State House of Assembly, in accordance with the said section and judgment of this honorable court in suit number FSC-DMCS 04/2022, the third defendant can validly contest the 2023 general elections. 2, whether upon proper construction of the provisions of sections 84.5(c)(1) and 2 of the Electoral Act and judgment of this honorable court in suit number FSC-DMCS 04/2022, the second defendant can, without recourse to the said provisions, declare the third defendant as the winner of the primaries into the seat of Goya Ngeji constituency of Yobe State House of Assembly. 3, whether upon the proper constructions of sections 84.15(c)(1) and 2 and judgment of the honorable court in suit number FSC-DMCS 04/2022, the second defendant can unilaterally declare the third defendant as winner of the primaries into the seat of Goya Ngeji State House of Assembly, Yobe State. relief sought. If the answers to the above questions are in the affirmative, the plaintiff seeks the following reliefs. A, an order of declaration that the second defendant having failed to conduct primaries with the accredited delegates as directed by the judgment of this honorable court in suit number FSC DMCS 3/2022 into the seat of Goya Ngeji constituency of Yobe State House of Assembly cannot validly fill the third defendant to contest seat of Goya Ngeji constituency of Yobe State House of Assembly cannot validly fill the third defendant to contest seat of Goya Ngeji constituency of Yobe State in the 2023 general elections. B, an order of declaration that the second defendant has no power to unilaterally change the name of delegates in negation of the judgment of this honorable court in suit number FSC DMCS 3/2022 and vote in the elections into the seat of Goya Ngeji constituency of Yobe State House of Assembly in the 2023 general elections. C, an order of declaration that the second defendant cannot, without recourse to the provisions of sections 5C1 and 2 of the Electoral Act and the judgment of this honorable court, declare the third defendant as the winner of the primaries into the seat of Goya Ngeji constituency of Yobe State House of Assembly. D, an order of this honorable court declaring the return of the third defendant by the second defendant as winner of the primaries of Goya Ngeji constituency of Yobe State House of Assembly as illegal, ultra vires, null, and void. An order directing the first defendant not to accept the candidature of the third defendant or any person from the second defendant into the seat of Goya Ngeji constituency of Yobe State House of Assembly in the 2023 general elections, and for such further or other orders as this honorable court may deem fit to make in the circumstances and justice of this suit. In support of the originating summons is an affidavit of 21 paragraphs and one exhibit deposed to by the plaintiff himself. The case of the plaintiff, as stated in the affidavit in support of the originating summons, are that the plaintiff is a member of the second defendant with registration number YBFKA 04-05202, and upon the platform of the second defendant, the plaintiff sought and obtained nomination form as one of the contestants who was supposed to contest in the primary elections of the second defendant into the seat of Goya Ngeji constituency of Yobe State House of Assembly on the 7th day of November 2022. That the plaintiff had earlier on filed a suit before this honorable court with suit number FSC DMCS 04/2022, seeking for the intervention of this honorable court to compel the second defendant to conduct a fresh election into the seat of Goya Ngeji constituency of Yobe State House of Assembly, to which this honorable court delivered a judgment on the 26th day of October 2022 and ordered the second defendant to conduct primaries into the seat of Goya Ngeji constituency of Yobe State House of Assembly. And that on the 7th day of October 2022, the second defendant purportedly conducted the primaries, which was marred by irregularities and not in accordance with the direction and order of this honorable court, Electoral Act, and guidelines of the second defendant. That the delegates have been illegally tampered with and their names changed. Those who voted were not validly accredited by the first defendant, and the first defendant could not produce the register of the accredited list of the delegates. That congresses were not conducted by the second defendant under the supervision of the first defendant, and in some places, congresses were not conducted at all. At 1, Daya Garu Chana Ward, 2, Mobi/Fusami Ward, 3, Goody versus Dozie/Godowoli, that political appointees and civil servants were among the delegates that voted. in which Danladi Shuaibu, who is a staff of Treasury Department of Fika local government, voted as delegate of Gadaka Shimberi Ward, that the second defendant committee called the deponent on Friday, 2nd day of November 2022 for another screening, and also gave him another nomination form to fill again. And the delegates, on the invitation of the second defendant, went to Fika, the local government headquarters, for revalidation on Monday, 7th day of November 2022, and that when they arrived, they were informed that elections will take place on the spot. That Fika is not the venue of Goya Ngeji State Assembly and not the constituency of Goya Ngeji, but Government Girls Secondary School Gadaka, GGSS Gadaka, and that the second defendant illegally changed the venue from Goya Ngeji constituency to Fika Ngalda State Assembly constituency. The deponent stated that 12 delegates were not allowed to vote in the purported primary elections. They were Soni Kadi from Gudi Dozi Godowoli Ward, Salisu Haruna from Shoye Garin Aba Ward, Dandaso Ali from Shoye Garin Aba Ward, Mohamed Sarki from Mubi Fusami Ward, Yusuf Tesha from Mubi Fusami Ward, Madu El Abdu from Gadaka Shamberi Ward, Sule Musa from Gudi Dozi Godowol Ward, Maimuna Manam Umaru from Shoye Garin Aba Ward, Salamatu Nasiru from Gadaka Shambere Ward, Halima Umaru Lampo from Shoye Garin Aba Ward, Hawa M. Baba Nahuta from Gudi Dozi Godowol Ward, and Haruna Alhaji Husseini from Shoye Garin Aba Ward. The deponent stated that it is in the interest of justice that the relief sought herein are granted as prayed. Also accompanying the affidavits are exhibits, marked as Exhibit Y2, which is a copy of the judgment of this honorable court dated the 24th day of October, 2022. Counsel to the plaintiff, Dr. Shamsuddin Magaji Esquire, in his written address formulated 3 issues which questions issue for determination. He argued together. The plaintiff seeks the resolution of the following questions. 1, whether upon the proper construction of the provisions of sections 84(5)(c)(1) of the Electoral Act 2022, the second defendant having failed to conduct primaries into the seat of Goya Ngeji Ward, Ngeji constituency of Yobe State House of Assembly in accordance with the said section and judgment of this honorable court in suit number FSC-DMCS 3/2022, the third defendant can validly contest the 2023 general elections. 2, whether upon proper construction of the provisions of section 85(c)(1) and 2 of the Electoral Act and judgment of this honorable court number FHC-DMCS 3/2022, the second defendant can, without recourse to the said provisions, declare the third defendant as the winner of the primaries into the seat of Goya Ngeji constituency of Yobe State House of Assembly. And 3, whether upon the proper constructions of sections 8415(c)(1) and 2 and judgment of this honorable court in suit number FSC-DMCS 3/2022, the second defendant can unilaterally declare the third defendant as winner of the primaries into the seat of Goya Ngeji State House of Assembly of Yobe State. I'll skip the submissions of Learned Counsel. On being served with the originating summons on the defendants, the first defendant filed its 3-paragraph counter affidavit, deposed 2/1 Zanna Mohammed Al-Ali on 19th January 2023 with 1 annexure accompanied by a written address of same date. The deponent stated that he is the litigation secretary in the law firm of the first defendant's solicitors, by virtue of which he is conversant with the facts of this case, except as otherwise stated to the contrary. That he was informed by Aliniki Ethan, Mr. Aliniki Ethan, a civil servant working with the defendant on 30th December 2022 at the hours of 2:30 p.m. in their office while briefing him about this matter, and whom he verily believed to be saying the truth as follows: that he is an electoral officer in charge of Fika local government area of Yobe State, that the first defendant was invited by the second defendant to brace and monitor a primary election for the nomination of a member representing Goya Ngeji State constituency in the Yobe State House of Assembly to be held on 7th November 2022. In Fika Town Hall, Fika local government of Yobe State, and that pursuant to the invitation, the first defendant attended and monitored the primary election in which the third defendant and one Abdulmumin Husseini, the plaintiff, contested, and that before the commencement of the primary election and accreditation of the delegates were conducted, and that the election proper commenced by 1:30 p.m. and one of the contestants in the person of Abdulmumin Husseini protested without any basis and asked on his supporters not to vote, as a result of which some of the accredited delegates withdrew and left, that the election continued, and at last the total number of 16 delegates casted their votes, out of which 15 votes was in favor of the third defendant and 1 vote was invalid. That the returning officer of the second defendant declared the second defendant as the winner and returned elected, and that the copy of the report he prepared in respect of the election is annexed and marked as Exhibit A. And that among the staff of the first defendant detailed to go and monitor the election on behalf of the first defendant, and they did, were himself, Mustafa Grema, Malam Kadi, and Hawa Mohammed Mamu. Also accompanying the affidavit is a sole exhibit marked as Exhibit A. Exhibit A, the report written by the electoral officer of the conduct of the primary election for Goya Ngeji State constituency to the first defendant. Counsel to the first defendant, K.M. Haruna Esquire, in his written address formulated a sole issue, thus, whether the first defendant has discharged his responsibility as required by law. I will skip the submission of learned counsel. The plaintiff filed a further paragraph affidavit to the counter affidavit of the first defendant opposing the originating summons. The plaintiff, as the deponent deposed, refers that he is one of the contestants in the purported primary elections of second defendant into the seat of Goya Ngeji constituency of Yobe State House of Assembly on the 7th of November 2022, and having read the counter affidavit of the first defendant, that paragraphs 1, 2, and 3, 1 to 10 of the counter affidavits are not true, concoction of facts and misleading. That paragraph 3 of the counter affidavit is not true, and he knows that Mrs. Afiniki Ethan is a female staff of the first defendant working as electoral officer in charge of Fika local government area of Yobe State. And that Mr. Ali Niki Ethan is not a staff of the first defendant. That paragraph 3, sub 2 of the counter affidavit is not true, that the initial venue of the purported primary election for the seat of Goya Ngeji constituency was Government Day Secondary School, Gadaka, and the second and third defendants changed the venue to Fika Town Hall in Fika local government area of Yobe State. That the counter affidavit, paragraph 3 of the counter affidavit is not true, as the plaintiff raised concern at the commencement of the purported primary election of 7th November 2022, into the seat of Goya Ngeji constituency of Yobe State House of Assembly when the second defendant wanted to use stooges to impersonate the delegates earlier submitted to the first defendant by the second defendant, allowing civil servants like Dahiru Shuaibu, a staff of Finance Department, Fika local government area of Yobe State, to participate as delegates among other irregularities. That paragraphs 3, 5, and 6 of the counter affidavit are not true, as the delegates who identified themselves with the plaintiff were not allowed to vote, and that the third defendant did not score 15 votes at the purported primaries to warrant being declared as winner, and there is no election results. And that paragraph 3 of the counter affidavit is not true, as the exhibit therein contradicts paragraph 3 of the counter affidavit, that he verily believes that the counter affidavit as filed by the first defendant is contradictory, defective, and an abuse of processes of the court, and that it will best serve the interest of justice to grant this application, as the defendants will not be prejudiced by granting same. Counsel to the plaintiff in his written address formulated a single issue for the determination of this honorable court, whether the first defendant can be said to have discharged his duties in the purported primary elections vis-a-vis the defects and contradictions in the counter affidavit of the first defendant, the exhibit in support, and the written address. I'll skip the submissions of learned counsel. On being served with the originating summons by the plaintiff, the second and third defendant filed a joint memorandum of appearance with leave of the court, sought and obtained. The second and third defendant filed their joint defense by way of counter affidavit and written address dated 4th January and filed 5th January 2022 to the plaintiff's originating summons. The counter affidavit contains 20 paragraphs deposed to by the third defendant. 6 exhibits are annexed to the counter affidavit, being exhibits A1 to A5 and exhibits B, respectively. The third defendant, one Ishaku Sani Audu, deposed to the fact that he is one of the contestants at the primary elections conducted by the second defendant on 7th day of November 2022 for producing a candidate for the general elections for the Goya Ngeji constituency of Yobe State House of Assembly, and by virtue of which position he is very conversant with the facts leading to this case. That the plaintiff herein also participated in the contest for the same post on the 7th November 2022, that withdrew after election has commenced, that the primary election conducted by the second defendant was not purportedly conducted, but same was organized and conducted in accordance with the directives and orders made by this honorable court, the Electoral Act, and the guidelines of the second defendant, and that the facts deposed in paragraph 11 of the plaintiff's affidavits are not true facts. Hence, the election was held after the delegates screened before they were admitted into the hall for accreditation by the officials of the second defendant, which was monitored and supervised by officials of the first defendant, led by Afiniki Ethan, electoral officer, while others were Hawa Mohammed, AEO, Mustafa Grema, HO, EPM, and Kader Maji, PAO, in the presence of law enforcement agents comprising of the police and Nigerian Civil Defense Corps, and that the first defendant had no obligation to produce the register of the accredited list of the delegates as alleged in paragraph 12 of the plaintiff's affidavit, as its duty was only limited to monitoring the conduct of the election. And that the facts deposed in paragraph 19 are not correct, hence all the delegates listed in the said paragraph were duly screened and allowed into the voting hall. Screening had even commenced when suddenly the plaintiff and one of his agents, Malam Ibrahim Ali Gadaka, withdrew and called on the delegates listed not to partake in the voting process in protest, and that having instructed those delegates to abstain from voting, the security officials controlled the situation and voting commenced with the available remaining delegates duly accredited, and they voted for the third defendant, who got 15 votes. 9 delegates refused to vote, while 1 vote was invalid. The deponent stated that he knows as a fact that both the plaintiff and Malam Ibrahim Ali Gadaka walked out of the venue of the election, commanding their delegates never to partake in the voting exercise. And so the 9 delegates complied with the instructions given to them by the plaintiff and his agents, and so refused to vote. That notwithstanding the withdrawal of the plaintiff, his agents, and those delegates, the second defendant, advised by the officials of the first defendant, and the law enforcement agents allowed the election to be conducted, whereby the third defendant won with 15 votes out of 25 accredited delegates, and that the list of the delegates was shown to him and annexed as Exhibit B. And at the conclusion of the election, votes counted favored the deponent, and he was declared winner by the officials of the second defendant, led by Honorable Abba Abari, that it is not in the interest of justice to grant the relief sought by the plaintiff, as the deponent and the second defendant will be seriously prejudiced if the relief sought by the plaintiff are granted. Also accompanying the affidavits are 2 exhibits marked as Exhibit A1, A2, A3, A4, and A5, and Exhibits B. Exhibits A1 to A5 is the copy of the summary results for the elected delegates of the second defendants, while Exhibit B is the list of the delegates for the respective wards. Counsel to the second and third defendant, Sanda A. Yelwa Esquire, in his written address in support of the joint counter affidavit and written address in opposing the applicant's originating summons in its entirety, raised 2 issues for determination. 1, whether or not the plaintiff has discharged the burden to establish his claims for declaratory reliefs. 2, whether or not the plaintiff who declined to continue with the election process midway and left the venue of the election could turn around to complain on the outcome. On the first issue, I'll submit the submissions of counsel. Counsel urged the court to resolve all the issues raised in favor of the second and third defendants and dismiss the plaintiff's case in its entirety, having been an afterthought, fictitious, and aimed at wasting the precious time of this court. Counsel applied for the cost of 1 million naira. The plaintiff filed a further affidavit to the counter affidavit of the second and third defendant, opposing the originating summons, which was deposed to by the plaintiff, who stated that having read the counter affidavit of the second and third defendants, same are not true concoction of facts, misleading, and not the actual reflection of what transpired, that paragraphs 1 to 20 are hereby denied, challenged, and or controverted, and that in further denial to paragraph 3 of the counter affidavit, The plaintiff only raised an observation at the commencement of the purported primary election at the gate of the elections venue when the second defendant presented some delegates who impersonated the delegates earlier submitted to the first defendant, while Anlad Shaibu from Gadaka, Sherimbe, who voted as delegate is a civil servant with finance department of Fika local government. That offer of temporary appointment and confirmation of appointment are annexed thereto and marked as Exhibit 1 and 2 respectively. And that in denial to paragraph 4 of the counter affidavit, the third defendant did not show that he has the consent and authority of the second defendant to depose to the counter affidavit. That paragraph 5 of the counter affidavit is not true, as the purported primary election into the seat of Goya Ngeji constituency of Yobe State House of Assembly was marred by irregularities such as using stooges to impersonate the validly elected delegates, allowing civil servants to participate as delegates, among other irregularities. That in further denial to paragraphs 5 and 6 of the counter affidavit, the second defendant, in addition to using civil servants as delegates, equally altered the list of delegates submitted to the first defendant by mischievously substituting one Mohammed Sarki from Mubi Fusami ward with one Ibrahim Baffa with ID number 103726 as exhibited in Exhibit A4 and Exhibit B, pages 3 of the second and third defendants' counter affidavits. That the deponent attached a CD plate containing video clips supporting the deposition and other irregularities marked as Exhibit 3. The deponent stated that the entire affidavit as filed by the second and third defendant is spurious, contradictory, defective, malignant, sham, and an abuse of processes of this honorable court, and that the counter affidavit as filed by the second and third defendants should not be granted by this honorable court. That it will best serve the interest of justice to discountenance the aforementioned counter affidavit, and the second and third defendants will not be prejudiced by the said dismissal. The further affidavit is accompanied by 5 annexures marked as Exhibits 1, 2, 3, 4, and 5, respectively. Exhibit 1 and 2 is the offer of temporary appointment and confirmation of appointment of Danladi Shaibu from Gadaka, Sherimbe, who voted as a delegate, is a civil servant with Finance Department of Fika Local Government of Yobe State. Exhibit 3 is a CD plate containing video clip supporting the deposition that the venue fixed for the primary election for the seat of Goya Ngeji constituency of Yobe State Assembly by the second defendant was Government Girls Secondary School, Gadaka, Fika, Yobe State, but the second defendant in a commando style changed the venue to Fika Town Hall, which is a different constituency under Fikangalda constituency of Yobe State House of Assembly, declared a result that is contrary to the affidavit of the second and third defendants, declaring a different person, not the third defendant. Exhibit D, Exhibit 4 is the summary result sheet for elected delegate for Mubi Kusami Ward. Exhibit 5 is the document titled Certificate of Electronic Generated Evidence pursuant to Section 84 of the Evidence Act 2011. There is a written address in support of the further affidavit of 7 paragraphs of the plaintiff arising from the counter affidavit of the second and third defendant, opposing the plaintiff originating summons to which learned counsel to the plaintiff, Dr. Shamsuddin Magaji, Esquire, formulated the following issues for the determination of this honorable court. 1, whether the second defendant can, without recourse to the judgment order of this honorable court delivered on the 19th day of October 2022, which mandated the second defendant to conduct fresh primary election using the list of earlier nominated delegates, can turn around and alter the list of delegates in favor of the third defendant. 2, whether from the facts and circumstances of this case, the plaintiff has proved his case to warrant this honorable court to enter judgment in his favor. And 3, whether the affidavit and the exhibit in support of the second and third defendants' counter affidavit vis-a-vis the written address is not defective and contradictory. Learned counsel argued issue above, 1 and 2 together. I will skip the arguments of learned counsel. In conclusion, learned counsel urged the court to discountenance the counter affidavit having no evidential value and dismiss the case for lacking in merit. In conclusion, counsel urges the court to invoke the provisions of sections 84(13) of the Electoral Act and hold so. The above are the submissions and arguments of counsel in this instance suit. In trying to resolve the issues identified in this matter, this honorable court will adopt the issue as raised by the second and third defendant counsel, Sunday A.L.Y. Esquire, in his written address in support of the joint counter affidavit and written address and in opposing the plaintiff's originating summons in its entirety, wherein a single issue for determination was raised, to which whether or not the plaintiff has discharged the burden to establish his claims for declaratory relief. The plaintiff filed an originating summons against the defendants challenging the imposition of the third defendant by the second defendant as the winner of the purported primary election for the seat of Goya Ngeji constituency of Yobe State, House of Assembly, Fika local government area of Yobe State, held on the 7th November 2022. The first defendant in the counter affidavit deposed to by litigation secretary in the law firm handling the first defendant's case, one Zanna Mohammed Al-Ghali, that he was informed by the electoral officer of INEC, thereby confirming the assertion that primary election held. The paragraphs of the first defendant affidavit is reproduced for ease of reference. By paragraph 3, sub 1, reads that I was informed by Mr. Ali Niki Ethan, a civil servant working with the defendant on 30th December 2022 at the hours of 2:30 p.m. in our office while briefing me about this matter, and whom I verily believe to be saying the truth as follows, that he is an electoral officer in charge of Fika local government of Yobe State, that the first defendant was invited by the second defendant to grace and monitor a primary election for the nomination of a member representing Goya Ngeji constituency in the Yobe State House Assembly to be held on 7th November 2022 in Fika Town Hall, Fika local government area of Yobe State. 3, that portion 2, the invitation The first defendant attended and monitored the primary election in which the third defendant, Anwan Abdulmumin Hussaini, contested. 4, that one of the contestants in the person of Abdulmumin Hussaini protested without any basis and asked all his supporters not to vote. As a result of which, some of the accredited delegates withdrew and left. 5, that the election continued, and at last, the total number of 16 delegates casted their votes, out of which 15 voted in favor of the third defendant and 1 vote was invalid. That the returning officer of the second defendant declared the third defendant as the winner and returned elected. That the copy of the report he prepared in respect of the election is herewith annexed and marked as Exhibit A. That's 310, that among the staff of the first defendant detailed to go and monitor the election on behalf of the first defendant, and they did, were himself, Mustafa Grema, Malam Kade, and Hawa Mohammed Mamu. The attached report Exhibit A, is titled Report on the Goya Ngeji APC House of Assembly primary election dated 7th day of November 2022 and signed by one Afiniki Ethan, electoral officer. The signatory of the report on the conduct of the election wrote that the process started with accreditation in the course there was a protest by one contestant, and that is Honorable Abdulmumin Gashinge, whose protest was that one of the person who was among the delegates ought not to be there. Following his protest, the man was asked to leave, which he left. The accreditation was thereafter carried out and concluded. The election, which commenced at 1:50 p.m., was initially successful and without protest until one of the candidates expressed dissatisfaction with the election without stating the basis of his dissatisfaction. He consequently asked his supporters not to vote. As there was no basis for his position, voting at the election continued to conclusion and results were declared. The second and third defendants in their counter affidavit asserted that primary elections held, paragraph 6 to 17 of their joint counter affidavits is reproduced for ease of understanding. By paragraph 510, that I know as a fact that the second defendant did not illegally change the name, the venue from Goya Ngeji constituency to Fika Ngalda State Assembly constituency. Hence, the venue of the election was within Fika local government. That the facts reposed in paragraph 9 are not correct. All the delegates listed in the said paragraph were duly screened and allowed into the voting hall. Screening had even commenced when suddenly the plaintiff and one of his agents, Malam Ibrahim Ali Gadaka, withdrew and called on the delegates not to partake in the voting process in protest. 12, that having instructed those delegates to abstain from voting, the security officials controlled the situation and voting commenced with the available remaining delegates duly accredited, and they voted for the third defendant, and who got 15 votes. 9 delegates refused to vote, while 1 vote was invalid. Paragraph 15, that notwithstanding the withdrawal of the plaintiff, his agent, and those delegates, the second defendant, by the advice of the officials of the first defendant and the law enforcement agents, allowed the election to be conducted, whereby third defendant won with 15 votes out of 25 accredited delegates. 17, that at the conclusion of the election, votes counted favored the deponent, and he was declared winner by the officials of the second defendant, led by Honorable Abba Bari. Meanwhile, the defendant, the plaintiff, in his affidavit, further affidavit to the second and third defendants' counter affidavit opposing the originating summons, by paragraph 3 C, E, F, up to paragraph 3S, 4 and 5, reproduced below. And I've read a substantial part of it, so I'll leave it. I'll read by paragraph 4, that the entire counter affidavit as filed by the second and third defendant is spurious, contradictory, defective, malignant, sham, and an abuse of process of court. 5, that the counter affidavit as filed by the second and third defendant should not be granted by this honorable court. Now, looking at the above reproduced processes before the court, there is so much contradictions in all the affidavits of the parties, starting with the first defendant's conduct. This honorable court, having observed that the first defendant, being the Independent National Electoral Commission, a body which is an umpire, have by their exhibit Annex 1 taken a stand that election was held peacefully and a winner emerged. Therefore, the first defendant and the second and third defendants are at idem that an election was conducted with accredited delegates, and by which the third defendant emerged as winner. While the plaintiff is contending that the purported primary election was marred by irregularities, such as contradictions in the list of delegates, some delegates not eligible to vote as they were never elected in the Congress, their names were just imported, using stooge to impersonate validly elected delegates. That civil servants were among the delegates that voted in contravention of the judgment of this honorable court, the Electoral Act, as well as the ground norm being the Constitution of the Federal Republic of Nigeria, 1999. The plaintiff produced exhibits in proof of such allegations, being offer of temporary appointment, confirmation of appointment, video recording of what transpired on the 17th day of November 2022, and also by Exhibit 4, document titled Summary Results Sheet for Elected Delegates 2022 for Mobi Fusami Ward. This honorable court observed that on the face of the exhibits have been defaced in some of the columns, in that some names have been crudely erased while some other names are written in the columns, which means there's suspicious activity that went on, I so hold. Documentary evidence is used as a hanger to test veracity of evidence, whether oral or documentary, or oral or by affidavit. Thus, documentary evidence is a hanger to base other pieces of evidence. The plaintiff's assertion is valid that primary election was not conducted in accordance with the provisions of the law by the second defendant, in that the second defendant and the third defendant ought to have annexed and showed the result sheet and or report of the primary election duly certified by the first defendant, who are by law empowered to supervise and report the conduct of the election, but only resorted to annexing Exhibit 1A to 5 being summary result for elected delegates 2022, which failed to indicate the total number of voters, number of accredited voters, total number of votes cast, valid votes and invalid votes. On proof of political party primary election, the Court of Appeal held in the case of Only versus Tunji and others 2012 LPLR that, I quote, I am of the view that the only proof of winning of an election is the election result duly issued. Where there are no results, mere averments by a party cannot stand by the conducting authority. End of quote. The second and third defendants have failed to produce a result sheet, a copy of a result sheet indicating the scores of the third defendant as scores of other aspirants. The burden of proof that valid primary election was conducted lies on the party that asserts that primary election was conducted. See the case of Agago and others versus Mimiko and others 2009 LPLR. In the instant case, the second and third defendants have failed to present evidence to prove that valid primary election was conducted. Either the certificate of return, result sheet, or the report of the first defendant who supervises and keep records of elections in Nigeria. See Ufomba versus INEC, Tazo versus Irora, 2016. This honorable court agrees with the submission of Learned Counsel to the plaintiff that the documents filed in support of the second and third defendants' counter affidavit exhibits A1 to A5 being the second defendant's summary result for elected delegates 2022, and that the report of result sheet of the purported election results of 7th day of November 2022 that allegedly produced the third defendant as winner of the elections is not sufficient to prove that there indeed was valid primary elections. Now, with the contradictions observed by this honorable court and the first defendants turned to its electoral officer that fresh primary election exercise was conducted in Goya Ngeji constituency by the second defendant, which was peaceful and was conducted under the supervision and monitoring of the officials of the first defendant with the law enforcement agents drafted to provide security cover is in contradistinction to plaintiff's averment and exhibits. This gave me a cause for concern because the first defendant in its counter affidavit and the exhibit therein contradicts paragraph 3 of the counter affidavit. The first defendant deposed at paragraph 3 that Mr. Ali Niki Ethan is the electoral officer of the first defendant in Fika local government area, whereas in a contradictory manner attached exhibit A, which shows the name of Afiniki Ethan, and that Mr. Ali Niki Ethan is not a staff of the first defendant. The first defendant affirmed above deposition in their counter affidavit, and at the same time, the first defendant in a quite contradictory manner annexed exhibit INEC 1 at paragraph 8.8 of the counter affidavit, alleging that the primary election was conducted peacefully in the presence of security men, agents of the candidates, and INEC staff who monitored the primary election. The first defendant is before this honorable court, talking from both sides of the mouth in one breath, deposing that election was conducted peacefully. And in another breath, using the name of a different person, one Ali Nikki Ethan. This honorable court cannot help but agree with the submission of learned counsel to the plaintiff that the above contradiction will leave this honorable court in a serious state of confusion as to which of the two testimonies or depositions to believe. Moreover, courts are enjoined not to pick and choose between contradicting pieces of evidence. In essence, this honorable court cannot pick and choose which version of the first defendant testimony to believe. Counsel referred the court to the case of Nwansu versus State, where it was held that the court cannot pick and choose which portion of the evidence of prosecution counsel to believe. It is either the witness is a truthful witness or an outright liar whose total evidence must be evaluated as credible or incredible as the case may be. See also Kaili versus Seelbach, 2015 LPLR. The first defendant cannot at the same time use Ali Nikki Ethan at paragraph 3(8) of his affidavit and turn around to use Afiniki Ethan in the exhibits attached. The case of Uday versus Nora, 1993, to NWLR, where the court held that a court faced with two conflicting pieces of evidence without explanation of the conflict is bound to reject both pieces of evidence. A party cannot blow hot and cold. He cannot affirm one at one time and at another time deny what he affirmed previously. He cannot approbate and reprobate. See also Celtel Nigeria versus Econet Wireless Nigeria Limited and others, 2014. As has been shown above, the first defendant has shown that it is biased, which is quite unfortunate. INEC ought to be and should not be seen and should be seen to be neutral at all times. In the case of Hope Ozodimma versus Osita Izunaso, number 2-12-11, 2011, 12 NWLR, my Lord 5BJC stated, I quote, with all the above, the third respondent, Independent National Electoral Commission, said it remains neutral in this episode, but still felt that the appeal should be dismissed. Independent National Electoral Commission, a body which is an umpire, should be seen to be really neutral at all times. In reality, a sympathizer should not weep more than the bereaved. Only heard cries at burials engage in such a mundane ploy. The position taken by the first defendant in this instant case is not in tandem with the admonition by the Supreme Court to the first defendant on similar cases. In the case of Attorney General of the Federation and others versus Alhaji Atiku Abubakar and others, the Supreme Court stated the Independent National Electoral Commission, INEC, by its statutory existence, is an independent body with constitutional powers to conduct elections in Nigeria. It must not only be an umpire, it must be seen in the eyes of reasonable men to be an impartial umpire in the conduct of an election. INEC must never be, by acts of omission or commission, place itself in a position where imputation of partiality in favor of one party against another will be leveled against it. Neutrality must be the watchword of the body. It must always remain fair and focused. The first defendant, as a neutral party and arbiter, did not heed the above admonition of the Supreme Court because the first defendant has stepped into the arena and is talking with both sides of the mouth, I accordingly hold. The parties in this instant action are the same parties in an earlier suit before this honorable court and were mandated to reconduct party primary election for the seat of Ngaldafika constituency. What's the name of Ngeji? Goya Ngeji, I'm sorry to.
As the court, please.
Constituency of Yobe State, House of Assembly. However, the parties are back while the plaintiff is contending that the orders of court were not complied with. The first, second, and third defendants are contending the opposite, hence this suit. This honorable court's quagmire is which of the two accounts given by the plaintiff and the first and second defendants should be believed by the court. Clearly, a situation of conflicting documents in an affidavit evidence had arisen, and this honorable court has a duty to use surrounding evidence and surrounding facts and documents to resolve the conflict and choose which among the documents to accept and rely upon in this case. Unfortunately, the documents before the court are not sufficient to meet the standards. There is too much conflict in the affidavit evidence of the parties. Such conflicts can only be resolved by oral evidence or pleadings. In the case of Azubuike versus Diamond Bank PLC 2014 3 NWLR, the court held where there are two contrary assertions, especially by way of affidavits, the court is not entitled to take a decision in favor of a party without resolving the conflicts, either by oral evidence or other documents, end of quote. In a situation such as this, the law is settled that where there's material contradiction in the case presented by parties, the court cannot pick and choose for the said parties. The only logical and fair course to take in the circumstance is to reject both accounts being contradictory. This court have no option than to reject the account with regard to what transpired on the day of the primary election for the state of Goya Ngeji constituency of Yobe State, House of Assembly. In support of the above position of the law, the Supreme Court in APC versus Marafa 2026 NWNR held that political parties must not act arbitrarily. They must act within the confines of their constitutions and electoral guidelines and in accordance with the provisions of the Electoral Act. Similarly, in Emeka versus Okadibo, 2012, 18 NWLR, the Apex Court held, until earlier, I quote, the court will never allow a political party to act arbitrarily or as it likes. A political party must obey its own constitution. The first defendant, end of quote, the first defendant cannot clearly and unequivocally admit in paragraphs of counter affidavit one thing and turn around in his counter affidavit to claim another. The appellate court held in the case of Ude versus Noara 1993, a court faced with two conflicting pieces of evidence without explanation of the conflict is bound to reject both pieces of evidence. A party cannot blow hot and cold. He cannot affirm one at one time and another time deny what he affirmed previously. He cannot approbate and reprobate. From the observation and perusal of this matter on the issue of primary election of the second defendant, there are disputes as stated earlier as to contradictory facts that are substantial material affecting the life issues of the matter and cannot be fought on the originating summons procedure where parties where affidavit of parties are so contradictory. This honorable court is fortified in this line of thinking by the endorsement of plenitude of Supreme Court decision, see Alpha versus Achai, 2018, Atago versus Unche, Alpha versus, Only versus Tunji, etc. All authorities and persons have a duty to obey the law of the land and act in accordance with the express provision of same. To do otherwise will enthrone arbitrariness, that the activities of political party cannot be operated arbitrarily or at the whims or caprices of select individuals, no matter how highly placed. Political parties are creations of the Constitution and statutes. Therefore, the affairs of registered political parties in Nigeria must be run in conformity and in obedience to the law creating them. The litmus test for the validity well-known of actions of a political party is that their actions must be consistent with the Nigerian Constitution, the Electoral Act, the Constitution of the party, and its guidelines. From the above outlined facts deposed to by the parties in this suit, juxtaposing same with the exhibits attached, especially the first defendant counter affidavit, as well as its exhibit Annex J, juxtaposing same with the plaintiff's CD plate containing video clips supporting the deposition that the earlier venue, Government Girls Secondary School, Gadakafi, Yobe State, fixed for the primary election for the seat of Goya Ngeji constituency of Yobe State Assembly was changed to another venue, Fika Town Hall, which is a different constituency under Fika Galda constituency of Yobe State House of Assembly by the second defendant in a commando style. Changing the venue of primary election, as seen in this video at the last minute, as in this instant case, is against the Electoral Act 2022 and therefore illegal. I so hold. I'm fortified in this line of thinking by the holding of the Supreme Court earlier in the week in the case of Honorable Namdi Isiani versus Honorable Jones Onyerere, 2023 Supreme Court, where it held that the purported primaries conducted by PDP for Imo West Senatorial District was illegal, having been carried out in Owerri and not in Olu, which is the headquarters of the senatorial zone, thereby violating Section 87 of the Electoral Act in 2022. The Supreme Court, in the same case by Agim JSC, held, since the time, I quote, since the time allowed by the Electoral Act 2022 for conduct of primaries and submission of candidates' names to INEC has elapsed, the PDP will not field any candidate for elections for the Imo West Senatorial Zone. See also APC versus Calfrey 2017 LPELR. From the above decision of the Apex Court, no party can conduct rerun outside the time fixed by law. I so hold. And any rerun order made without jurisdiction will have disastrous consequences on the candidates of that political party. The lesson that politicians ought to learn from this case is flagrant abuse of the Electoral Act 2022 and the constitution of the political party does not pay. Political party must allow internal democracy in their parties and avoid arbitrariness, which perpetuates injustice. Whoever decides to disobey the law should have themselves to blame. And from discordant submissions of counsel, it is clear that the second defendant did not conduct valid primaries in accordance with the extant laws to warrant declaring the second defendant as winner, declaring the third defendant as winner of the purported primary elections. I hold accordingly. The implication of such misconduct is for this honorable court to invoke the provision of Section 84, sub 13 of the Electoral Act 2022, which reads thus: where a political party fails to comply with the provisions of this act in the conduct of its primaries, its candidate for election shall not be included in the election for the particular position in issue. This honorable court, having been fortified by the above provision of the law, as well as the recent decision of the Supreme Court in Honorable Nnamdi Azikiwe versus Honorable Jones Onyerere, in conjunction with the earlier cited judicial and statutory authorities, hereby toward the same line and pursuant to the provision of the Electoral Act 2020 and the Constitution of the Federal Republic of Nigeria 1999, this honorable court holds that since the time allowed by the Electoral Act 2022 for the conduct of primaries and submission of candidate names to INEC has elapsed, the All Progressives Congress, APC, shall not field any candidate for elections for the seat of Goya Ngeji constituency of Yobe State House of Assembly in the 2023 general elections. This matter is hereby dismissed, each party to bear its own cost. This is my decision.
As the court pleases. My lord, we are deeply grateful for the sound, and let me use the word unprecedented as far as decisions of court in respect of compliance with political party guidelines and constitutions. Is not actually new, but rather this decision reaffirmed earlier decision of the courts to the effect that constitution and guidelines of political parties are meant to be obeyed. And with this, we are deeply grateful, my lord, and we pray to Almighty God to continue to strengthen you, to guide and protect you in your tasks of administering justice. Thank you very much, my lord.
Thank you, Counsel. Those are the only two cases for today. Yeah, thank you, Counsel.
Thank you, my lord. We are most obliged with the judgment, my lord.
Su su je su karɓo.